Civic Media, inviting you as always to call in to engage with Calvin and me at 844-967-2789, either directly or through the Civic Media app. Looking forward to your comments, your questions, especially your questions and inquiries. Let's begin in our first syllabus item this morning. We all know well what is going on at many universities, many colleges across the United States of America. We have protest encampments. We have protests of various kinds focused upon the war in the Middle East, Gaza, and Israel. Many of the student protests, the encampments, the other activities, which we will talk about, focusing upon requests, petitions for those universities and colleges to divest, to engage in divestment when it comes to companies that may be supporting the war effort with respect to Israel, the IDF against Hamas, and the war going on in the Middle East, in Gaza generally. Some of that focus simply upon the government's position, our State Department, our executive position on the war in Gaza. All of that, as you know well, as you have digested the news, focusing our campus, a lot of our campus attention upon the Middle East, things beyond our borders. And you know as well that there have been differences in the ways in which these protests have proceeded. Some of them have been completely quiet. And by that, I do not mean ineffective necessarily, but they have not been violent. They have been situations where there is advocacy, some of it strong, some of it aggressive, but not in any ways violent. Other cases, in other instances, at the other extreme, we looked at places like Columbia and UCLA, where yes, indeed, there was violence involving a takeover of buildings. In the case of Columbia, Hamilton Hall, that iconic building there on the University there at Columbia. UCLA, just Thursday morning, finally, a bloody encounter between protesters and other protesters, counter-protesters, brought to an end by the involvement of the police there at UCLA, as it was in Columbia, and all sorts of differences in between, as this has spread across and populated our campuses, including places like Brown and Rutgers and even Northwestern, not too far from us here in Wisconsin, where the university engaged in discussions with members of the protesting groups, the students and others as well, and has indeed achieved some peace, perhaps an imperfect peace, but some agreements about how indeed we can all live together on those campuses without the violence. And those have involved some negotiations, some agreements about future discussions in many of those campuses, including Northwestern, where university officials and some of the pro-Palestinian demonstrators struck a deal, if you will, that brought an end to the protest encampment on that campus and involves some future disclosures of information, some future discussions in the fall about divestment. And that, of course, even that kind of resolution is not without its controversy, more advocacy under the First Amendment. It has drawn some criticism from some of the Jewish leaders, some of the Jewish students there. And that, of course, all of that is what America is all about, the capacity to disagree and to engage in discussion. And that is indeed what leads us to our civics aspect this morning about what the First Amendment says, what it doesn't say, what we can take away, admittedly, in a fairly superficial way this morning. This is not going to be a law school class. When you go to law school, when you've had other classes, the professors, the legal scholars will spend weeks, if not months, talking about the implications of the First Amendment because there is a lot out there. There's a lot of good case law. There's a lot of controversial case law out there about the application of the First Amendment. We're going to do sort of a general analysis of what the standards are when it comes to things like restrictions on the First Amendment and areas where government should not become involved, to give you some sense, perhaps some mechanisms for applying those standards to what you're seeing right now. I will let you all do that on your own because these things also involve a certain amount of subjective assessment. Some of it subjective, much of it subjective. But we'll talk about the First Amendment, which of course says the Congress, that's how it begins, although that has been interpreted, as you also well know, to mean the government. The government shall make no law. And there are also expressions, of course, in the First Amendment about religious liberty, the requirement that government not become involved in the establishment of religion. But the focus this weekend is on this language in the First Amendment that says, the government shall make no law abridging the freedom of speech or of the press or of the right of the people to freely assemble. That's what James Madison wrote. That's what our Constitution says. The first Congress passed that, of course, as you know, as a part of the Bill of Rights, and that remains a key part of our Constitution. Those are some of the first words in our Bill of Rights. And so, how have the courts interpreted that? What kinds of things can government do and not do when it comes to applying that very broad language, that very inspirational language, aspiration for justice? How do courts interpret all of that in understanding what the First Amendment means and what it does not mean? Let's begin by talking about some restrictions. Restrictions that indeed the courts across time have permitted governments, and that includes the local institutions and state institutions and federal institutions to apply. They're called time, place, and manner restrictions. Time, place, and manner. And those are also referred to as content neutral restrictions. We'll get to all of that. Time, place, and manner restrictions. This goes to my fundamental proposition, my fundamental notion that there's no such thing as a right in the Constitution, including the First Amendment, that is unconditional. All of those rights, including the First Amendment, have some restrictions because we live in communities, because we live in a society of people, and we need to balance those individual rights to free speech and advocacy and assembly, and yes, of the press as well, with a concern about our overall safety and security and well-being. And so, the courts have said that governments can, in fact, impose restrictions on the timing, when it is you actually advocate in the public domain for changes, do other things in the advocacy pool, the places where you can do that advocacy. Yes, indeed, government can limit your access to certain areas. They can ask you, they can require you to submit permits for permission to occupy certain areas. And yes, indeed, they can also restrict to some extent the manner in which you even go about communicating. The issue may be noise, the issue may be the kinds of signs and posters that you may use. All of that, a balancing test in content neutral restrictions that the Supreme Court and other courts have said the governments can indeed impose. Content neutral meaning just that. We're not imposing restrictions based upon the content, the substance of what you say. Those have got to be content neutral, but governments can indeed tell you when you cannot engage in advocacy in the public domain. You can, as a part of a government official action, engage in limitations on place and also on, again, the manner, the very manner in which those content neutral messages are conveyed. All of that can be done. Even so, under many cases, the word is, the law is, the limitations have to be narrowly tailored to serve a significant government interest. They've got to be focused upon exactly what the government wants to do, and they have to leave some alternative ways of communicating messages. As we continue here on Amicus Law Review, more about the standards for the First Amendment, including some understandings of access to our campuses and beyond. This is Amicus, a law review. My name is Jim Santelle, your host for our weekend program here in the broadcast stations of Civic Media. We are beginning our weekend broadcast this weekend. Along with Kelvin, we're taking your phone calls, your comments through the Civic Media app at 844-967-2789, beginning our discussion this weekend with the campus protests and providing some civic instruction, if you will, a little bit of a mini law school this weekend on what the First Amendment means and what the courts have done when it comes to interpreting what you can and cannot do under the First Amendment. We were chatting right before the recent break about all these time, place, and manner restrictions that can indeed be imposed upon a group of people or an individual seeking to petition government, seeking to advocate in the public domain about various issues. Those kinds of things, time, place, and manner restrictions permitted under the First Amendment. Government can indeed limit those things in a content neutral way. You cannot prohibit expressions under the First Amendment in terms of subject matter. I cannot establish as an alderman, as a legislator, as a federal official, limitations on subject matter. So, for example, if I wanted to advocate about issues in the area of labor or abortion or environment or immigration or, yes, indeed, the war in Gaza, the courts have looked at limitations on subject matter with a high deal of skepticism and even high scrutiny, basically prohibiting those kinds of things. That's where the First Amendment really takes its hold. What you cannot do, of course, is push back on reasonable limitations related to time, place, and manner. You can negotiate with local officials about the circumstances, and that is also contemplated by many of the decisions that the Supreme Court and others have issued. That is this notion that while there are rules and standards, much of it has to do with the circumstances, the physical layout, the particular facts of a case, and the situation that prompts the advocacy in the public domain. A restriction could also run afoul of the content neutral touchstone, the standard, if you will, if those circumstances surrounding the enactment, the passage, the placement of the time, place, or manner restriction somehow reveals a government intent to favor or punish some particular messages. In other words, even if it doesn't come right out and say you can't talk about the environment, you can't talk about abortion or about immigration or about the economy, even if it doesn't come out and say that, if there's something about the mechanism by which the restriction was applied and enforced, something maybe in its legislative history that suggests that there really is another animus, another reason for going ahead and imposing some restrictions, it may well be that government is violating the content neutral notion when it comes to passing all of that kind of restriction. All of this to say that there are rules, and yes, they are applied, as the Supreme Court has said, according to the specific circumstances. Some of those circumstances relate, of course, to whether or not the venue, as with colleges and campuses, whether they're private or public. The First Amendment applies very broadly and very expansively to public institutions, public places, private institutions, private locations, including colleges and universities. No. However, most of our colleges and universities across our nation, whether they are certainly public, but private as well, have adopted these fundamental notions about the First Amendment, permitting on campuses the fundamental expressions of the First Amendment, the invocations of it, so that the lines, if you will, when it comes to public and private institutions, not blurred, but nonetheless, the rules for the most part do apply across the board, even though in the private institutions, they are not enforceable, if you will, under the Constitution itself, probably in a court of law. Most universities have adopted them even so. All universities, public, private, public places, private places that are not places of academic education, have also embraced and understand what the courts have also told us about violence. And that is just basically this, that the First Amendment advocates for and promotes and encourages, once again, freedom of the press and freedom of speech and freedom of the people to freely assemble. What the Supreme Court has said the First Amendment does not do is permit violence. It does not permit violence against other people. It does not permit destruction of property, all those kinds of things that would move beyond the protections of the First Amendment, whether we talk about content neutral distinctions or other things under the standards, the touchstones there. Violence is not protected by the First Amendment, nor are affirmative calls to violence. Affirmative calls to violence, invocations to go and commit violent acts, property, people, all those kinds of things. That is an area of expression, and it is expression that is not protected by the First Amendment. Indeed, there's an entire catalog, if you will, of jurisprudence out there that talks about fighting words and about the kinds of things that are said in the public domain that if indeed they incite violence, and that again, that can be a determination made by a jury, a judge, made by government, made by people on the scene. If you are in fact inciting violence of some kind, destruction of some kind, that is not protected by the First Amendment. And so all of those standards being used right now, no doubt the lawyers are spending lots of time these days with government officials and also with administrators on the campuses of our public and our private institutions across the country, including right here in Wisconsin, determining where the line is, making informed judgments based upon what the law is, and then also applying what the courts have also encouraged, which is the exercise of discretion. The campuses and other places of education, of common company, if you will, of gathering, often say that indeed, while it is possible to prohibit certain kinds of protests, the reality is that in the interest of promoting the First Amendment, we may permit some things to happen that may not be within the four corners of the First Amendment itself. And so, for example, an encampment that is not the subject or is not permitted by virtue of a permit, whether it's in a public park, on a campus, some other place, some movement up and down a sidewalk in a street, without authorization by a local government, the time, place, and manner restrictions that we talked about. Government will often look at that and say, we will permit you to do that, even though we might be able to enforce some restrictions against you. Why? Because we want to embrace in America, in our town, in our state, in our city, the basic tenets, the basic operations, the practices of the First Amendment. And so that is often done, and it is endorsed. It is endorsed by the courts. And we have seen a lot of that also on campuses as well recently, where administrators and others will say, although this particular encampment, this particular activity, this particular marching may not be the subject of authorization, we will let it go forward because it's not violent. It's not crossing that line. There's no incitement to violence. And we encourage the discussion, especially on campuses, where we have discussed before on this broadcast, the all-important notion of education, of sharing views that are different from our own, of hearing from others, and sometimes hearing offensive language. That is also contemplated and protected by our First Amendment. Things we don't want to hear, that's what America is about. That is especially what campuses are all about, private and public as well. The courts have encouraged administrators and government officials to find that line, based upon the circumstances, should be animated by the definition of that line, should be animated by the circumstances. And that ensures both an adherence to what the First Amendment is all about, but also establishes that there are lines, and those lines can be crossed. And when, as on the campus of UCLA, there is bloodshed, when protesters and anti-protesters, other protesters engage in fight and people are getting hurt, that is crossing the line. And that is when, yes, administrators, as they did at the campus of UCLA, very early this past Thursday morning, called in the police to bring this to a close. That's when you cross that line. At Columbia, also in Hamilton Hall, at some point, the administration said the destruction of property there, the smashing of windows, the destruction of other hallways and furniture, those kinds of things, that cannot be tolerated. That is not protected. And now we have to make the decision to call in the police, the law enforcement authorities, to bring that to an end because it has gone too far. But all of that analysis based upon not a moving standard, but a standard that's premised upon what is happening now in the moment. We anticipate that our administrators and especially our law enforcement have in front of them not only these basic standards about time, place, and manner, restrictions that can be made, but also the notion that content neutral approaches have got to be a part of any establishment of rules and regulations, and the notion once again, the First Amendment is not unconditional. There are times when expressions and advocacies go beyond the protections of the Constitution, and that includes especially violence against people, against places, against property. And that is when the protections of our Constitution, of the Bill of Rights, no longer attach. All of that presented and offered to you, not in explanation or in justification or in reasonable analysis of every single thing that has happened in America on the campuses of our universities and colleges, but to give you some sense about the decision-making process that goes along in determining where the First Amendment adheres, where it does not. And decisions made, by the way, not only by administrators, but yes, by law enforcement, and yes, indeed, the students themselves and others who may advocate for change, for things that they feel strongly about in all of those areas that are content specific and do have substantive content to them. All of that offered to you this weekend on our broadcast as we think about the First Amendment generally and the First Amendment protections that are guaranteed to us, not without conditions. As always, we appreciate your phone calls, your comments as they come into our weekend broadcast. And right now we've got Bill calling in from Oconomowoc. Bill, appreciate your comment, your question, your inquiry to me this morning about the subject matter of our broadcast. Bill, are you with us this morning?
Can you hear me okay?
Yes, Bill, I do
Can
hear
you hear
you.
me okay?
Yeah, we do hear you loud and clearly, Bill. Yes, go ahead.
Do you remember when you and I revisited what you're talking about now about a couple months ago, and I asked you ethics charges on a number of lawyers and maybe judges could be about to happen? Do you remember that discussion we had?
Well, I remember you calling in and we had a discussion about many things. Yes, but go ahead, Bill. What's your comment or question this morning?
Well, here's my point. You would know more than anybody. Are we getting close to that point where ethics and judges' ethics and a lot of these attorneys that are linked with Trump are about to be questioned themselves?
And I'm going to take this in a slightly different aspect and answer your question by saying that the reality is that lawyers are already being taken in that direction, right? We know about people like Rudy Giuliani and Sidney Powell, and especially John Eastman recently, subject of review of their ethical predicates, if you will, their status right now. Their bar licenses are being examined. And that applies to me, to every other practicing lawyer out there. We are indeed, Bill, as you've affirmed again on this weekend broadcast, we are always, as lawyers, held to standards. We talk about being the officers of the court. And even just this past week, in the subject matter we're going to take up very shortly here, the trial in Manhattan, the judge talking about the obligations of lawyers appearing in front of him as officers of court to follow ethics rules and principles. That is always the case, frankly, whether you're in court or out of court. Bill, appreciate the comment, appreciate the call as well. And we also have Mark calling in from Prairie du Sac. Mark, your question or your inquiry this morning?
Yeah, it's kind of interesting. This is kind of going beyond, a little beyond what's going on right now. But under the expansive nature that the Supreme Court appears to be looking at to expand presidential powers, finding some secret wording in the Constitution that gives the executive, the power to off his political opponents. That they're toying with it. They consider
absolutely,
that
and right, and Mark, appreciate the comment. I'm going to maybe have you stay on hold here. We're going to chat about the Supreme Court in a later segment here on our weekend broadcast, talking all about what the Supreme Court is doing and not doing as we continue our discussion here on Amicus, a law review. This is Amicus, a law review, and yes, we're talking about lawyers. We're talking about courts. Mark asking some good questions, making some good points about our Supreme Court and the ways in which they decide cases. Going to take up that encouragement, that invitation by Mark, and talk now about the Supreme Court and revisiting something that we talked about just last week, and that is this major oral argument in this case involving Trump versus United States versus Trump. This is the immunity argument. And we spent a lot of time in our broadcast last weekend talking about the oral argument itself, offering some views about what is going on here with our United States Supreme Court, just as Mark was beginning to chat about some of the issues that he also identifies among our judiciary, commenting last week about the turning of this issue into something substantively important when in fact it is not. The notion that a president, our chief executive, under the Constitution, under the laws, 240 years of laws, would be immune from criminal prosecution under some regimen to be decided by the Supreme Court. All of that I have offered up, and as have many others, as an example of the Supreme Court arguably going down a path they do not need to go down and getting it wrong when it comes to trying to parse out what are official and personal acts, what are official things done by a president and those things done in a personal capacity. This weekend, approaching it from a slightly different perspective, and that is a statement made by Richard Nixon way back in context of his interviews with David Frost. Some of you may remember that as well. Nixon said at the time, well, when the president does it, it means that it's not illegal. And Frost said, by definition, he said, exactly. If the president, for example, approves something because of the national security, then the president's decision in that instance is one that enables those who carry it out to carry it out without violating a law. And while that language from Richard Nixon may strike many of us, including me, as being inappropriate and even offensive under the Constitution, he's onto a bit of something that the Supreme Court about 10 days or so ago could have understood better. And that is what makes the questions about things going on inside official capacity exercises so difficult is the same thing, exactly the same thing that makes Trump versus the United States so very easy. Richard Nixon was speaking about cases where the president is clearly executing a core presidential power. He's talking about something in the national security area. But that left, of course, obscure in the oral argument in Trump versus the United States. The thing that was left obscure that is that Donald Trump is not, according to the allegations in the indictment against him, was not executing some presidential power in any legally relevant sense. When he did what? When he engaged in the behaviors charged in that grand jury indictment. None of the hard questions of presidential immunity are raised by that case, which is what we have said and advocated for on this broadcast and others. The only hard question is, why did the members of the Supreme Court permit this to sound a whole lot more complicated? Why did the lawyers, at least for Donald Trump, go down this road of suggesting that this is a difficult case when in fact it is not? What is absolutely clear about our Constitution and our constitutional tradition, of course, is that the president has no official authority or duty when it comes to selecting the next president, not in his or her official capacity. It's a question even whether Congress itself has anything to do with the selection of the president beyond what we know as the counting electoral votes. Instead, where does that power inhere? It's the states. It is the states, right, that have the primary and perhaps exclusive power to determine the elements necessary for choosing the president of the United States of America. And we know that by virtue of what we have seen and our own constitutional access. The state legislatures are given the exclusive power to appoint in such manner as they may direct presidential electors. That's in the Constitution. In 2020, the court held that the power to tell presidential electors how they vote and how they must vote, that was also the subject, again, of analysis and affirmation by our courts. The point of all of this is that the president can, in fact, play a role in this process, but it's not official. The president does not have an official authorized role to play in a free country. All of us free to lobby a legislature, to reach out to a secretary of state, to reach out to other elected officials. But it doesn't mean that when a president does try to play a role in that process, he or maybe one day she is doing that in anything other than a private capacity, in a personal capacity as a citizen, a candidate, not a president who's performing the duties of his office. Or more directly, he or she is not executing an official act. And that's what the Supreme Court, from another perspective, failed to understand when it pursued all of this. Donald Trump, according to the allegations in the complaint, again, the indictment here, assumed innocent until proven guilty, not exercising any power to police presidential elections given to him by the Congress when he engaged in the acts charged in that grand jury indictment. Again, because neither the Congress nor the president has any constitutional power to police how the states carry out their obligation to participate in a presidential election. The actions, as alleged, were therefore not official acts because the authority to perform those acts flowed not from the Constitution nor from any federal law. The president acting not with any shield of federal law, but merely as an ordinary citizen. That's the personal part of it. That's the point of Michael Dreeben responding to the Supreme Court justices who are suggesting that somehow, according to the allegations in this indictment, there is this distinction between personal and official, when in fact there is not. There is not. This is an ordinary citizen trying to bring about the political result that he wanted, all personal in nature. And for that reason, once again, we come back to the fundamental assessment of what happened in front of our Supreme Court last week and determine with some certainty that the Supreme Court right now is wrestling with this strange and peculiar bifurcation between official and personal actions of Donald Trump, as alleged, when in fact there is nothing of the sort that is official. Amy Coney Barrett said, well, gee, can't you go back and parse out the personal stuff from the official stuff? Michael Dreeben appropriately is saying, no, you cannot do that. As I have said previously on this broadcast, I am still hopeful that the Supreme Court goes back and during the course of the deliberation undertaken right now, as it begins to assemble this all-important decision about presidential immunity, comes back to its senses and says, no, indeed, there is no such thing that protects a president in the performance of his duties that is criminal in nature, protects from prosecution. We anticipate the Supreme Court hopefully will come to that conclusion, but we'll report on that in the weeks ahead here on our weekend broadcast, Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle, and I am your host for, yes, this second hour of our weekend broadcast. This our weekly weekend assessment, a review, our analysis of things like government actions and legal principles, and yes, indeed, the aspiration for justice in our nation and beyond. Thank you so much for joining me for this, our second hour. As always, we are taking your phone calls as well at 844-967-2789. You can also get into our program and engage in our discussions through the Civic Media app. Again, 844-967-2789. My wonderful producer, Calvin, and I here ready to take your inquiries, your questions about the many different areas on our syllabus this weekend. Thank you. Thank you for once again joining us for this discussion here on Amicus, a law review. We are talking, as we always do, about the United States Supreme Court. They issue opinions at this time of year that have dramatically changed and sometimes not changed the very geography of our nation. Appropriate to understand that of the 62 cases on the docket of the Supreme Court in this its 2023-2024 term, 62 cases the Supreme Court has decided it will review. It has already issued opinions in 18 of those. 18 of those cases already the subject of its opinions. And so, for example, we have talked on this broadcast about a recent decision of the Supreme Court in a case called Muldrow versus City of St. Louis, a unanimous decision. Keep that in mind, an important aspect of this. All 9 justices determining in the end that workers can indeed pursue employment discrimination claims over job transfers, movements inside their employment without having to show that an involuntary move with which they disagreed caused some significant disadvantage, like harm to career prospects or a change in salary or rank. What that means is, again, that under Title VII, the options for showing employment discrimination in the terms and conditions of employment are broader, or at least now that they are defined under Muldrow versus City of St. Louis, according to all the members, all of them, all 9 of them unanimously agreed to this broader understanding of the circumstances under which employment discrimination claims can be made. We know as well that 9 of the justices, all of them unanimously, in a case called O'Connor-Ratcliffe versus Garnier and Linkey versus Freed, actually 2 cases brought together, they said this about social media. Focus a lot on social media, this docket. Public officials, they said, can be liable for blocking or deleting their critics from their social media accounts, but only when they're acting in an official capacity and with actual authority from the government for which they work to speak on behalf of that government. In this pair of unanimous decisions, again, the court said that public officials are still private citizens with their own constitutional rights, but if information is accessible only on those personal accounts, and a public official blocks a critic, prevents them from getting access to it, that's when rights to constitutional access to information can in fact be unconstitutional. A significant case again, O'Connor-Ratcliffe and Linkey versus Freed, that also decided. And a third case I'll highlight again this weekend, also unanimous, which again is a part of the appropriate identification of what's going on here. We're getting a lot of cases where they all agree. So those are coming out now. A case, of course, as you know, ballot eligibility for Donald Trump. Colorado cannot disqualify Donald Trump, could not disqualify Donald Trump because of his actions before and during the January 6th attack. And that decision issued way back in March. Justice said that the Constitution does not permit a single state to bar a presidential candidate from national office, and they declared instead that the responsibility rests exclusively with the Congress and not the states, keeping Donald Trump on the docket there in Colorado and across the United States of America. Other states also looking to that. So 3 cases among the 14 highlighting this weekend here on our broadcast, but many others undecided. We'll give you some sampling this weekend and in the weekends ahead of what we're still anticipating from the Supreme Court. It is going to be a busy time. This is the time, mid-May, into mid-June, approximately, when the Supreme Court starts to issue some of the decisions. We have talked already again on this weekend broadcast about this case, Trump versus United States, the immunity case. That will be coming out highly, highly unlikely, depending upon what they decide, that will be a unanimous decision. It appears that 6 members of our Supreme Court may be going in the direction of identifying this bifurcated analysis, where there are some areas where if they're official conduct, if there is official acts, that those might be protected by some concept of immunity. But if they're personal, those are not. A distinction, again, that I and many others who look at this from not only a legal perspective, but also a broad constitutional and future of the republic position, view as ridiculous, as a position that cannot be embraced. We will see what the Supreme Court does. That one very highly controversial, argued just on April 25th. We know as well there's another case that we have talked about on this broadcast, Fisher versus United States. Doesn't involve Donald Trump by name, but plainly implicates once again this prosecution pending against him right now in the federal district court in the District of Columbia, alleging election interference. 4 counts there brought by a federal indictment. That case suspended while the Supreme Court determines whether or not there is immunity in that other case. And also, arguably, depending upon what they do in Fisher, that could also have an impact upon not only the prosecutions, the convictions of hundreds of people that have been prosecuted and sentenced, and in many cases incarcerated under a particular statute. And the question there in Fisher is whether prosecutors properly charged them, and arguably, derivatively, whether the grand jury in the Trump case properly charged Donald Trump using a law that makes it a crime to obstruct or impede an official proceeding. In this case, the disruption of Congress's certification of the 2020 election results. We know that well from what we saw on January 6th. The question is whether or not the statute applies. That's Fisher. That was argued on April 16th. We will see. We will see what the Supreme Court does. It appears there from the tea leaves that a majority of the Supreme Court, as we have said previously, the majority of the Supreme Court in the Fisher case appears inclined to say that the application of Section 1512, which is the statute under which Mr. Fisher and others, and yes, indeed, Donald Trump has also been prosecuted, is not applicable, at least to on-the-ground activities. Question whether or not the statute is applicable to the charges against Donald Trump in the other discrete case against him. That will be the subject of even more litigation, depending upon what the Supreme Court says. The third major case coming out of the Supreme Court having to do with Donald Trump. Other things we're also anticipating in the area of guns as well. Guns for suspected domestic abusers. This is the Rahimi case, United States versus Rahimi. An argument held way back on November 7th. The question there, the big gun case on the docket of the Supreme Court this term, whether a federal law disarming individuals who are subject to domestic violence protective orders issued by state courts, whether that violates the Second Amendment. There is a federal law that prohibits anyone, again, under the Second Amendment, one of those situations where the Second Amendment, not unconditional, has restrictions on it. A federal law that has been upheld up to this point that says if you are subject to a domestic violence restraining order, you cannot possess a weapon. You can't hold one, you can't use one, you can't sell one or transfer one. And Mr. Rahimi, challenging that in this case, argued before the Supreme Court back in November, questioned whether or not the Supreme Court will uphold that federal law in one of its major guns cases. And it appears that they are poised, that is the 9 members of the Supreme Court, poised probably to allow that ban to remain in place. This is a bridge too far, especially with the facts from Mr. Rahimi and his particular conduct. We'll see what the Supreme Court does in the Rahimi case having to do with the intersection between federal law and this domestic violence restraining order situation. Another big case we're still waiting for a decision on. This is called Garland. Yes, that's our Attorney General. Garland versus Cargill. This is the bump stock ban. You recall this case is whether a federal ban on bump stocks, that is when attached to rifles, these devices, as you know well, speed up how quickly bullets can be fired from a firearm, whether that's permitted under federal law. And the question is whether or not bump stocks are firearms, and the fact that they're attached to firearms to increase the velocity to how quickly these bullets can be fired, whether that renders them subject to review, analysis, and regulation by the ATF and the federal government generally. A federal ban on bump stocks implemented by the Trump administration continued under the Biden administration. We all recall well the Las Vegas gunman, 2017, killing dozens of people, the deadliest mass shooting in modern U.S. history there in Las Vegas. That was a bump stock case. And that's what prompted the regulation now being challenged in the Supreme Court, determined sometime in Garland versus Cargill whether or not bump stocks are illegal in the United States or whether the prohibition on them violates the Second Amendment. Then we've got all sorts of abortion cases, which is also going to lead us to our discussion this weekend about what's happened in two of our states. We've got this case called FDA versus Alliance for Hippocratic Medicine. Remember this case? Argument not too long ago, March 26. The question there, whether to restrict access to this key abortion medication used predominantly in the United States along with a secondary pharmaceutical called mifepristone. It's used in more than half of all U.S. abortions and was first approved by the FDA way back in 2000. Abortion medication, of course, has increased in importance as more than a dozen states have restricted or banned abortion since the Supreme Court overturned Roe versus Wade. That number approaching even 20 now these days, in the wake of the Supreme Court decision in Dobbs. This question of mifepristone, much related to the Dobbs decision, and the question is whether or not the FDA decision to permit that drug to be in the public domain, the authorization by the FDA back in 2000, tested and analyzed ever since then, in the quarter century since then, whether the FDA should be second guessed. It appears that the courts seemed unlikely to restrict the access to that drug, mifepristone, but we will also be taking a look at that as well. More of this analysis, a brief review of what the Supreme Court has in its docket coming up as we continue here on our weekend broadcast, Amicus, a law review. This is Amicus, a law review, and we are talking in this segment of our weekend broadcast about what we can anticipate from the United States Supreme Court in the weeks just ahead. Yes, the next 5, 6, maybe 7 weeks out there, going to be populated by lots and lots of decisions in many different areas of our lives and livelihoods, as the Supreme Court has done virtually every year in our contemporary lives, deciding major cases. This is the time period, early, mid, late May into June especially, early June especially, a hot period of time for the Supreme Court to begin to issue these decisions, including as we were talking about cases involving reproductive rights, privacy rights under the Constitution, all of that in the wake of the decision almost 2 years ago now, June of 2022, and a decision issued by the majority, not a unanimous verdict, not a unanimous judgment by the Supreme Court, but by an opinion written by Sam Alito, finding that the privacy rights, to the extent that they adhere at all in the Constitution, do not extend to abortion rights, to reproductive rights. That, of course, is the Dobbs decision that has changed dramatically what is happening in America with respect to abortion rights and access. We talked already about this major case, FDA versus Alliance for Hippocratic Medicine, determining in the wake of that decision whether or not the drug mifepristone, in the wake of Dobbs, and it's no longer finding this position of privacy rights in the Constitution for abortion, whether the FDA's decision to authorize that drug as reasonably safe and secure, whether that should continue. Likely that the Supreme Court will afford the FDA the discretion that it has exercised in finding that it is, for the most part, a safe and secure drug tested over a couple of decades and more. Likely that mifepristone will be affirmed, if you will, in that sense by the Supreme Court, overturning a lower appellate court and certainly a district court judge that found that mifepristone was not properly administered and overseen by the FDA. There is another case that's also pending in the area of privacy rights and reproductive rights, abortion rights, and that's Idaho versus United States. We've talked about this on our weekend broadcast as well. Oral argument held just recently, April 24th. The case, once again, Idaho versus United States. The question there, whether a federal law requiring emergency room care for life-threatening cases means that emergency room doctors in states across the country that have strict abortion bans must nonetheless terminate those pregnancies in certain circumstances. The Biden administration taking the view that this federal law requires that medical doctors in ER situations preserve the life vitality and sustenance of women when their lives are being threatened, and are obliged to perform those abortions to continue to address their health situations. In a situation like Idaho, in that particular state, it has passed a state law that prohibits abortion entirely. And the question is, which one of those holds? The Supreme Court, again, hearing argument on this case on April 24th, determining again whether or not the federal law will be supreme over the state law. The assumption is that the federal law, pursuant to the Supremacy Clause, will hold, and that the interpretation given that law by the Biden administration will indeed supersede, if you will, the case, the status of the state case, the state law in Idaho that prohibits abortions entirely. Very significant abortion case pending there in the Supreme Court, having to do with the intersection between state law and federal law when it comes to abortion. Many other cases also pending in future broadcasts of this program. We will talk about those other things as they're coming up, and certainly we will also discuss the cases as they are decided by the Supreme Court. We are talking, therefore, about the cases before the Supreme Court having to do with abortion. And indeed, because of the wake of the decision in the Dobbs case, we know that a lot of the decision-making has gone on now in the states. You know a lot about that. That's been happening for 2 years, ever since the Supreme Court decided that Dobbs case in June of 2022. Focusing this weekend on Amicus, a law review on 2 states in particular. Lots of activity just this past week in the states of Arizona and also Florida. Arizona lawmakers just this past Wednesday repealed an abortion ban that first became law when Abraham Lincoln was president, and a half century before women won the right to vote. Now, where do we get to that? How do we get to that point in Arizona where this major thing happened? And what are the implications? What does this look like going ahead? Well, a recent Supreme Court decision there in the state of Arizona. This is the state Supreme Court, not the federal Supreme Court, ruling by 4-2, they upheld the 1864 law that prohibited virtually all abortion procedures. They said physicians are now on notice that all abortions, except those necessary to save a woman's life, are illegal. Now, needless to say, that prompted a lot of reaction on all sides of the political aisle when it comes to this hotbed issue of abortion and privacy rights, not just in Arizona, but also across the country. The state attorney general there said she's going to decline criminal prosecutions of doctors and others, describing the ruling of the Supreme Court as unconscionable and an affront to freedom. On the other side of the docket, you have a group called the Alliance Defending Freedom saying we celebrate now the decision that allows the state's pro-life law to again protect the lives of countless innocent unborn children. So what happens? Well, in the wake of that, putting this 1864 law back into place or simply affirming its applicability there in Arizona by a 16-14 vote. The state Senate just this past week, with the support of every Democratic senator and yes, 2 Republicans, this is a bipartisan 16-14 vote, repealed that 19th century law. And the governor, her name is Katie Hobbs there in Arizona, she signed that bill. And as a result of that, the state will now be governed by a 2022 law, another law that was passed, obviously long after the 1864 law, but following Dobbs, that prohibits abortions after 15 weeks of pregnancy. Interestingly and concerningly, no rape or incest exceptions in that law. So the 2022 law now becomes the state law in Arizona, almost. And why do I say that? Well, the repeal of the 1864 law by virtue of Arizona law does not become effective until 90 days after the legislature adjourns. It has repealed the 1864 law, but the repeal of that doesn't become effective for 90 more days, which means that more than technically, right now, the 1864 law remains in place. It will go out of applicability, effectiveness, 90 days after they leave, and the 2022 law goes into effect. We will talk more about all of that and also talk about the state of Florida here on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle, your host for these remaining segments on our weekend review of now talking about abortion in America, talking specifically about major events in two states, in Arizona, and yes, in just a moment or so, Florida, things that happened in the wake of the 2022 decision by the Supreme Court saying that there no longer is, if ever there was, a position vested inside the Supreme Court that establishes a privacy right to reproductive rights and abortion. Talking about the situation in Arizona, where just this past week, the governor signed legislation repealing this 19th century law that imposed a prohibition on virtually all abortion procedures, effectively now going into effect 90 days after the legislature leaves and moves on to other things. And also in the meantime, effectively keeping that 1864 law in place. All of that sort of confusing procedural history, prompting an awful lot of people to say we need to do something even in the interim to ensure that the 1864 law does not take place in that state. But the governor, of course, the attorney general has said they will pursue no prosecutions of anyone under that 1864 law. But the 2022 law is also getting a lot of attention because it too prohibits abortions after 15 weeks of pregnancy with no exceptions for rape or incest. Look to Arizona for a lot more action there. Indeed, State Senator Ana Hernandez, who is one of the sponsors of the repeal measures, said, "We are standing in a moment of Arizona history." Certainly that is the case for Arizona as they wrestle with the 1864 law, the 2022 law, and the interplay between a state Supreme Court, legislative action, executive action on this issue. More certainly coming out from the state of Arizona, coming out also from the state of Florida, where once again we have action initiated by a state Supreme Court. This once again is not the federal Supreme Court, it's the state Supreme Court in Florida. A recent Supreme Court decision, this one is 6-1, says that based upon our analysis, finding no clear right to abortion embodied in the privacy clause of the state constitution, the petitioner here cannot overcome the presumption of constitutionality, and therefore basically keeping in place a Florida ban after 6 weeks of pregnancy passed by the legislature. Interestingly, in a separate ruling on the same day, same Supreme Court said, even though we're going to find that ban, that 6-week pregnancy ban, remains in place, by a separate ruling, by a 4-3 decision, a very much split decision, the state Supreme Court there said that a proposed constitutional amendment, a change in the Constitution of the state of Florida that would guarantee the right to an abortion before viability. That's the language of the proposed constitutional amendment. Usually before viability means around 24 weeks or so. That's the state of the medical condition today. That will be on the ballot in November. And the Supreme Court says, yes, indeed, that can be on the statewide ballot come November. And so that 6 weeks ban on abortions, which is now effective, and it became effective as of May 1, just this past week, just this past Wednesday. The 6-week ban on abortion is now effective in Florida. And two things will happen. One is that in November, months from now, the people of the state of Florida will go to the polls and determine whether or not they want to override, to supersede that 6-week ban by passing what's called Constitutional Amendment 4. This is the amendment, once again, that allows abortions before viability. That would need more than 60% of the votes in that November polling. So that is coming up. But in the meantime, the 6-week ban remains in place in the state of Florida, prompting an awful lot of advocacy, as in Arizona there, about this constitutional amendment, again, that would establish guaranteeing the right to an abortion before viability, usually around 24 weeks, whether that will become the law and the constitutional standard in the state of Florida, superseding what the legislature previously did. An awful lot of advocacy. We have seen recently the governor there, his name is Ron DeSantis, advocating that the law remain exactly as it is. This was his proposal in the past. This is his legislation passed by the state assembly and the state senate. Nonetheless, he is advocating for the defeat of constitutional amendment 4. And you also have others, including our vice president, Kamala Harris, there just this past week, advocating that constitutional amendment 4 should be passed by 60% or more of the people of the state of Florida. All of that happening in the states of our country as this issue continues to percolate up undeniably, not just in our courts, not just in our legislature, not just in our executive branches, but yes, indeed, in polling places. This continues to be a major issue. And the Supreme Court, as we indicated earlier in this broadcast, has not gotten out from under the need to address abortion issues. They've got those 2 cases pending for decision sometime soon in our nation's history. All of that happening in our courts of America. We also spend some time on this broadcast talking about financial crimes and economic crimes and other things affecting the future of our nation. And we talk also about civil liability, things brought by private parties, brought by the government to enforce the civil law, including, yes, that's right, the antitrust laws of our nation. We have not previously focused much, if at all, upon this major case pending right now in the federal district court in the District of Columbia involving Google. It is the strongest challenge by the federal government to so-called big tech's power, and it's nearing its climax right now. Just this past week, closing arguments in the wake of a weeks-long trial, the United States of America, brought by the Antitrust Division of the United States Department of Justice against Google and others. On Thursday and continuing into Friday, lawyers for the Department of Justice, state attorneys general, and Google deliver their final arguments in this years-long case initiated many years ago. It's called the United States and Others versus Google. And the question again is whether this tech giant broke federal antitrust laws to maintain its online search dominance. Those arguments concluding now, a decision anticipated by the district court. This case a civil case tried in front of Amit Mehta. We have talked about him because he has been presiding over other cases, other criminal matters involving a completely different subject matter, and that is the insurrection. He presided over many cases involving defendants brought into court by the U.S. Attorney's Office in the District of Columbia for the insurrection on January 6th. Now he is presiding over this case weeks long about whether or not Google violated our nation's antitrust laws. And he will make a decision, presumably sometime in the months ahead. Interesting case, interesting arguments. The government, of course, claims that Google competed unfairly when it paid Apple and some other companies billions of dollars to automatically handle searches on things like smartphones and web browsers. Google, on the other hand, insists, as it did during the course of the trial, during the course of oral argument here, that consumers use its search engines because it is the very best product that is out there. The trial, once again, as I indicated, the biggest challenge to date to the power of today's tech giants, which have defined, frankly, an era in our nation. Billions of people around the world depend on these products for information and for social interaction and commerce. American regulators have also sued Apple and Amazon and Meta in recent years for like monopolistic behaviors. Google's case is likely to set a legal precedent for that group. An awful lot of people looking at this and saying this is the most important decision and the most important antitrust trial of the 21st century. At the heart of the case, again, is Google's dominance in online searches, which generates billions in profits, as we know, annually. The government, once again, the Justice Department maintaining that Google's search engine conducts nearly 90% of all web searches. The company spent about $26.3 billion in 2021 alone to become the default search engine on browsers like Apple's Safari, Firefox, And what that means, at least according to the government, is that it automatically selected for users out of the box those browsers and those search engines, and all of that again presented during the course of the trial. Apple's share about $18 billion, according to an awful lot of reports. It's arguing again that those contracts were designed to defend its search business monopoly and hurt the ability of other companies like Microsoft and DuckDuckGo to compete in this area. Now, Judge Mehta, during the course of oral arguments, the closing arguments of recent days, has grilled both sides. And so not a lot of indication, unlike some of the Supreme Court cases that we've talked about, not a lot of indication coming out of Judge Mehta about how he is going to resolve this dispute between Google and its leadership and the leadership of the Department of Justice, the United States of America, trying to poke holes, frankly, in the closing arguments in this landmark monopoly case, questioning the government's argument that Google's dominance had hurt the quality of the experience for searching for information online. Ask them about that, the quality of the product. Didn't this in fact actually enhance in some ways the quality of the online experience, but also pushing back against Google and defending its central argument that it isn't a monopoly because, according to Google and its lawyers, Google uses other companies like Amazon to search for shopping items and TikTok to search for music clips. In other words, pointing directions in other areas. Certainly, I don't think that the average person, Judge Mehta said, would say that Google and Amazon are the same thing. And so Judge Mehta, looking at both sides and wondering aloud whether or not one side or another has the better of the argument. The judge questioned how it would be possible for another company to beat Google out as the search engine that automatically populates for Apple's web browser Safari. He proposed, for example, that it could be impossible without having billions of dollars to spend to truly build a competitive search engine and billions more to pay Apple. He prodded Google's lead litigator on the argument that companies like Amazon and ESPN are two competitors at the same time to its search engine. He noted, for example, interesting, that he wanted to know who the shortstop, that if he wanted to know who the shortstop for the Baltimore Orioles was in 1983, he would most likely use Google. And the point of all of that, this discussion between the judge, Judge Mehta, and the lawyers for the Justice Department and the lawyers for Google, is that he is testing the legitimacy, the strength, the power of the arguments in both sides, interrupting them about issues that he is identifying. Again, no jury here, no jury to decide this case. Judge Mehta will be determining whether or not the allegations of antitrust claims against Google held up. An awful lot of predictions that he is not going to find that Google has engaged in so much violative behavior that it needs to be broken up, but that would be one of the remedies. Unlikely he will do that. He may do some things short of that along the way, some determination about whether or not some things in Google's practices do require some remedial action, some intervention by the courts based upon the Justice Department's allegations. Are there things short of breaking it up? Should they pay some fines? Should they do some other things in terms of their future operation to address what may or may not in the end be antitrust violations? That will probably come out long after the Supreme Court cases in June are decided. Judge Mehta now has that so-called under advisement. He can make his determination whenever he would like. It is no small thing. Weeks and weeks of trial testimony, of evidence, of documents, of arguments along the way. He's got a lot before him, a lot on his docket. We will continue to monitor that and report back on what the judge says in this Google antitrust case here on Amicus, a law review. This is Amicus Law Review. This is our final segment of our 2-hour broadcast this weekend. Thank you once again for joining me and Calvin, my wonderful producer, for our broadcast this weekend. We are concluding in this, our last segment, by returning, yes, as promised, to that trial going on right now in the Manhattan courtroom, presided over by Judge Juan Merchan. This is a criminal case. It is a state criminal case, not a federal case, brought by the district attorney. His name is Alvin Bragg, alleging that Donald Trump, the singular defendant there, 34 counts of allegations of false statements, false representations, false documents when it came to paying off Stormy Daniels, Karen McDougal, and others for keeping quiet about previous alleged sexual liaisons, relationships before the 2016 election. And again, as I said at the outset of our broadcast this weekend, that's the premise of the presentation by the DA, which is that this is also an election interference case accomplished through the violation of New York law by failing to come forward with accurate reports, invoices, checks, register entries, all those kinds of things. Lots of things going on in this case. And again, we are entering into arguably the third trial. We've had 2 weeks of testimony, not every day. The judge is taking Wednesday off to permit the parties and him to do other things. He also has a docket going on. But we know that from just this past week, we've have a number of additional witnesses being presented again as a part of the prosecution case. The prosecution has the obligation, as you know, of presenting evidence beyond a reasonable doubt to prove the allegations in this 34-count charge against Donald Trump. And it's only if they meet that burden beyond a reasonable doubt to the unanimous decision of the jury that's, yes, there in the courtroom there in Manhattan, if they meet that burden, only then, by unanimous verdict, can the defendant, Donald Trump, be found guilty of one or more of those counts. Plainly, there are appellate rights that could follow this as well, which we have also talked about in the New York system, like they are in the federal system. But this past week, again, we have gotten more testimony presented by the prosecution as a part of this case. That includes direct testimony, questions asked by the prosecutor, and then also, as a part of our system, cross-examination by the attorneys for Donald Trump. And they have pursued that. And that is the appropriate part of the process. They are there to test the legitimacy, the strength, if you will, the power of the government's case. And so we concluded the previous week with some testimony of, for example, Rona Graff, who was one of the so-called custodial document witnesses, one of the technical witnesses. She's a former executive assistant to Donald Trump. And she came in and she told a number of things about her relationship, obviously, with Donald Trump, and said that, yes, indeed, in the database that the Trump organization has at Donald Trump's encouragement, he has information, contact information about both Stormy Daniels and also Karen McDougal, the principal subjects of these payments to them, in some cases through the National Enquirer, in some cases, according to the allegations in the indictment, through Michael Cohen and Donald Trump. She came in and talked about that. And what does she do? She provides a little bit more information to establish this tie, this link, which the government is obliged to show, if it can do it at all, between Donald Trump and his operation and these particular women. She basically establishes that, yes, indeed, there plainly was communication between them, followed by this fellow named Gary Farrow, Farro. He's the financial loan manager for First Republic Bank. And he is also not a direct fact witness, but he comes in and talks about the ways in which he established a predicate loan of $130,000, a home equity loan, that was extended to Michael Cohen, who will be a future witness here, probably next week or maybe the following week or so. He comes in and talks once again. He provides the financial records, the documents, the transactional piece that will support, presumably, what Michael Cohen will say down the road based upon the transaction between Michael Cohen. He gets this home equity loan, $130,000, which he then turns over to Stormy Daniels to pay her off, to be quiet about this previous sexual liaison. So we get those witnesses who are adding more information to the overall story. Independently, any of those witnesses does not establish proof beyond a reasonable doubt, but collectively, as the witnesses go forward, they add more to the story. They hang more things on the overall story that was told by David Pecker, the first and principal witness up to this time. We also had the testimony just this past week of an attorney named Larry Davidson. If David Pecker talked about the dark side, if you will, of publishing, or at least publishing in the National Enquirer, catching and killing stories, saying things that are not true, publishing things or not publishing things based upon not the legitimate interest in journalism, but upon political motives, Larry Davidson comes in and he talks about how he has clients, and the purpose of his work on their behalf, clients, is to manage things like this. He is the attorney for both Karen McDougal and Stormy Daniels. And he comes in and says, yes, he brokered what he called consideration, basically the agreement for their silence in exchange for those monetary payments. He is subject to a lot of cross-examination along the way, and that happens very, very clearly and emphatically. We have Douglas Dowse, who comes in, who provides some forensics for an exchange, an electronic exchange, a recorded conversation between Michael Cohen and Donald Trump about the Karen McDougal matter. All of that comes in. And then finally, just late this week, the testimony of Hope Hicks. And she comes in and provides more information about what was going on in the context of the Trump campaign 2016 after news of the Access Hollywood tape breaks. I'm going to talk in the future more about credibility of witnesses. I would offer here that Hope Hicks, both in terms of her demeanor and substance, not only provides more information about what was going on at the time, connections with Donald Trump, conversations with all of these players, but also does it in a very compelling way. The final comment I would make is also about something that happened outside of the jury this past week, and that is the judge admonishing the defense and the defendant in particular about his public statements, that somehow this so-called gag order, a word that once again makes me bristle, this order that prohibits him from talking about or calling names to witnesses and jurors, somehow prevents Donald Trump from testifying in his own behalf. And yes, indeed, Judge Juan Merchan says in the courtroom late this past week, let me be very clear, and here's the civics lesson from him, and also as we close out on our broadcast, that nothing about the order imposed upon a defendant here in any case prevents a defendant, if he wants to do it, from testifying. That's the right. Nothing prevents the directions of the court from preventing the defendant from testifying. More about those civics lessons from the bench of Judge Juan Merchan, from other courtrooms across our nation, as our civic media broadcast here in Amicus, a law review, continues in the weeks ahead. Stay with us for those discussions. Join us for those discussions. Thank you for being with me this weekend. Have a great week, everybody.